Hello everyone and welcome to today's Connect and Learn webinar. I'd like to begin by acknowledging the traditional owners of the land on which we meet today and pay my respects to their elders past, present and emerging. I extend that respect to Aboriginal and Torres Strait Islander peoples listening today or in the future. My name is Rebecca and I will be facilitating today's webinar, which is on working in the criminal justice system in collaboration with the AOD sector. This webinar is part of a series of Connect and Learn webinars designed to support AOD clinicians throughout Victoria. This webinar series is funded by the Victorian Department of Health and hosted by Turning Point. We do, where possible, want our webinars to be interactive. So please use the Q&A function to ask questions. Please don't use the chat function. None of the questions will be answered live. I'll collate the questions at the end and ask our presenter at the end. We will be recording this and this will be made available on our website. Our presenter has kindly agreed to share the slides from today. We encourage you to stay to the end of the webinar and complete the exit survey when the QR code appears on the final slide. We will also send that via email later today. Now I'd like to introduce our presenter, Tristan Brumby-Rendall. Tristan is the drug outreach lawyer with a focus on the City of Yarra. Tristan is also a qualified psychologist with over 13 years experience working in forensic mental health, trauma and torture counselling for refugee and asylum seekers and youth justice. Thank you, Tristan, so much for giving us your time today. We're really, really interested to hear about this presentation. Thank you.
Thank you very much for that welcome, Rebecca, and welcome to everybody here. I'd just like to echo Rebecca's welcome to country for myself. Meeting on the lands of the Wurundjeri people in the Kulin Nation. I'm aware that there's people from, I think, all over Australia, New South Wales, Queensland, Northern Territory, so a shout out to the people there. Yeah, welcome. It's a little bit daunting to see the numbers of participants just continue to climb into the hundreds. So hopefully today can be used to you. As Rebecca said, my background is a combination of health and the law. So hopefully I have a fairly unique kind of perspective on, the challenges, but also the benefits that can come across working multidisciplinarily, and particularly how people working in the AOD sector can assist people with their legal matters and vice versa. Slides. The focus of what we'll be talking about today is I'm going to give you a brief overview of Fitzroy Legal Service, where I'm from, and the drug outreach lawyer. That's what DOL stands for there. Also giving, I guess, some tips on how to potentially get better legal outcomes for your clients, or at the very least, avoid worse ones. And then a little bit of a focus on understanding some of the hidden aspects that can occur in the law, which may affect people who use drugs. We sometimes talk about the burger with a lot, referring to charges, so I'll elaborate on that. I've had a bit of a rundown on where people are from, and I'm aware that there's health organisations, academic university organisations, government organisations, courts, Department of Justice. So I guess I'm coming at it from largely a health perspective, and some of the information might be basic for people that work in health, or might be very basic for people that work in the court system or the justice system. Hopefully, though, by sort of focusing on both of those aspects, the people in the health can get a little bit more understanding about the justice, and the people in the justice can get a little bit more understanding about the health. So just about Fitzroy Legal Service briefly. Look, it started in 1972. It was there are arguments that we were the first ever non-Aboriginal community legal centre, although Redfern has some things to say about that. As it started out, it was free legal advice for all, and still is. It's run originally by volunteers, and there's still quite a long history of volunteers, particularly our night service, which is a free drop-in service for all kinds of generalist law. That continues to be run by volunteers, so people that are either studying law, as well as a lot of very experienced lawyers as well, giving up their time. Also a very long history of working not just in casework, which is, I guess, what I do a lot of, which is individual representation, but also broader-based advocacy, trying to change laws, public interest cases. One of the examples more recently is being involved in the Veronica Nelson inquest where Fitzroy Legal Service appeared as an interested party and as an expert on how the justice system can fail people, particularly people that use substances. In terms of what we do, we have a whole host of different programs. In terms of, I guess, probably the ones that are most relevant to the work that you do, we have the Drug Outreach Program, which services the City of Yarra and the City of Darebin, and basically people that have some contact or even a very loose connection to any of those local government areas or the services, AOD services within that area we can see and provide criminal representation. There's a night service that provides advice for all kinds of generalist matters. We have a criminal law casework team. We have people based at the NJC, which is the Neighbourhood Justice Centre Court in Collingwood. We've got a Q+ law, which is a criminal and generalist legal service for people that identify as LGBTQI+. We also have the Women's Integrated Legal Outreach, which is a specialist program for criminalised women. Also has 2 social workers attached as well. We have a partnership with St Vincent's Health, and there's also a legal handbook. So I'll plug that. People can, in organisations, it goes through all aspects of law, particularly things that can affect our clients like tenancy, fines, criminal law, and provides it in a hopefully a very accessible way, not like an academic textbook, and it can be a really great resource for understanding how the law works. As I said about the DOLE program, it started in 2001, largely in response to the heroin use that was occurring through the 90s. It was initially in the City of Yarra, then expanded into the City of Darebin. Look, it's an outreach model. So the outreach is I service at the medically supervised injecting room in North Richmond, YSAS, which is a youth service. You can see other services there. Odyssey House, which is a rehab, rehab, a long-term rehab, co-health. And look, we try and find reasons to represent people. So, I've represented people that may have only ever attended one of those services once. We appreciate that it can be difficult for people to get criminal law representation. So we try as much as we can to find reasons. If we can't help, we will find someone that can. A little bit more about DOLE. As I said, it's predominantly criminal casework. You can see from the statistics there that our clients, probably unsurprising to a whole host of you, have got a whole host of sort of social disadvantage and vulnerabilities. Very high rates of mental health conditions. AOD use is almost uniform with all of them, and that's, I guess, a consequence of the outreaches that we work at. Heroin and alcohol is the most common within the City of Yarra. Most likely that reflects the fact that the supervised injecting room, medically supervised injecting room, is in the City of Yarra. Methamphetamines and alcohol is the most common in the City of Darebin. For people that are coming interstate, these are, I guess, inner city, inner north local government areas in the Melbourne area. Also can see that there's quite a high proportion of people that are homeless or sleeping rough. Again, that can lead to challenges in terms of legal representation. The main one being just trying to actually contact clients and get them to attend court. A lot don't have phones. So we really do rely very heavily on our outreach partners and forming those partnerships there. As I said, it's an active outreach, so I will attend those services weekly. I also am open to referrals and things outside of that time. I'll be attending court during the week as well, but yeah, as I said, it relies very heavily on a strong partnership with the AOD service, because often that's the only way I can get in contact with clients. So I guess the more responsive that I can be, it benefits hopefully the client, and hopefully also by attending out on outreach, the service gets to know me, the clients get to know me that attend regularly. We can, I guess, piggyback off what we call borrowed trust. Often clients will be quite suspicious, with good reason, of court systems and even defence lawyers being seen as part of that system, but they'll often trust, their drop-in centre or some of the caseworkers or AOD workers they have, or peer workers. So I guess if I can have a strong relationship with the service, then I can kind of piggyback off the relationship the client has with the service, and then hopefully get better outcomes. Look, this is just a big slide. I don't expect you to know it, but in broad terms, it just sort of looks at what the drug outreach lawyer's aims are. And it's individual on the left, working with clients. So it's client representation, representing through all aspects of court, as well as broader based advocacy to try and change the laws. So I guess getting on to the part of which hopefully will be of most use to people, and that is how do we get better outcomes, or as I said, at least avoid worse outcomes um, for clients. I've got the cliche of the iceberg there, and again, you would have probably come across the metaphor before, but I guess it's recognizing that metaphor cuts both ways, in that often the legal service may know far more about the legal matter than potentially the AOD service or the health service, but equally, it's very, very frequent that the health service will know far more about the client. And it's, I guess, being able to, both of us work together to be able to use that information. On many occasions, a lawyer may not even know that the client has a worker. Sometimes they can be reluctant to talk about drug use. It doesn't happen so often in our service because, as I said, by definition, we're working with the AOD service. But if they have a lawyer that's outside of this, they may not know. But as I said, if they have a lawyer outside of Fitzroy Legal Service, or if you're calling from somewhere else in the country or in Melbourne, the lawyer often might not even know, and the client may not bring it up with the lawyer because they think, well, I don't want to bring up the fact that I'm using substances or getting AOD because that will make it worse for me. Um, Equally, I guess the client may not reveal they've even got any legal matters. So I guess we always encourage our AOD workers to inquire about whether or not the client's got any outstanding legal matters, and then that active sort of inquirement, because if they do, then you can, I guess, pass them on and refer them on to a service such as ourselves, and hopefully result in some representation. I know that, as I said, coming from a health background prior to working in law, there's that bi-directional nature of AOD and the law, in that AOD issues can exacerbate your contact with the criminal justice system, and equally the stress and anxiety around the criminal justice system can potentially exacerbate people's AOD use and issues. So again, I think it's in everyone's interest generally to work together, always with the client's authority, of course, and I guess that will be assumed all the way through here, that we're operating with client's authority. The three areas that I'm going to focus on in terms of getting better legal outcomes for clients are court letters or reports, how to help a client prepare for court, and how to work with the legal representation. I'm focusing on those areas because they're the ones that come up most in terms of questions, and it's also the ones that when we flagged doing this talk that we believe to be potentially the most help. As I said, some of you may know some of this already, some of it will be new. Hopefully we can say something that's of use to all of you though. So I guess focusing on letters most of all, why do we have the letters? Courts love proof. So on one hand, I guess I can stand up as a defence lawyer and say the client has been engaging with Living Room, or engaging with YSAS, or engaging at Odyssey House, or in rehab. But magistrates can be suspicious of defence lawyers, and I guess it's always a great benefit to be able to actually show that, no, here, it's not just me saying that this is happening. We have a letter from the organisation confirming that that client is engaged, or has the potential to be engaged. Again, coming from, I guess, a health background, I know that sometimes organisations can be wary, or individual clinicians can be wary of providing letters, and what they're going to be used for. Are they going to get called into court to have to back up the letter? If at the first port of call, I would always say that talk to your own organisation. I'm sure that they probably have individual policies on providing court letters, but I'll also just go through a little bit about what they're used for, why we use them, and things that are of benefit to put in there. The one thing I really want to emphasise is that the court letters aren't used to establish guilt or not. So unless it's a very, very specific request, as in, can you confirm that the client was at your service at this particular time? And we may be using that as to confirm that maybe the client isn't, like as an alibi, I guess. But again, that almost never happens. And the vast majority of what we're actually asking is we're looking at to show the rehabilitation efforts that the client is making, or the potential rehabilitation services that might be available for them, or to provide a little bit of background about potential mitigating factors. As I said, I really want to emphasise that we don't use it up there to go, look, this person's not guilty because they've got all these things going on in their life. The court is generally a two-step process, particularly for pleas. They establish guilt first, and then and the guilt really is just a matter of law. So mitigating circumstances or a client's hard social circumstances doesn't go to guilt. It goes to how much they should be punished. So when we get these court letters, it's not about saying, I don't think the client did it, or you can't possibly punish them. It really is about saying, look, this is the options that are available for the client, or this is how we know the client, and this is the support that we can offer them, and this is, we know some of their background. The reason that we really use them, particularly in pleas, is because when you do a plea, for those of you that don't know, what happens is the prosecutor, the police will get up and they will read the summary. So that's the, I guess, alleged facts of what happened. And that'll be something like, on this day, the client attended, did this, we found them with this, they did an interview, and this is what they said at the interview. Then the magistrate only hears that, and then they only get told what the criminal priors are. So from the court's point of view, they've got to decide how to sentence a person when the only information they have is the alleged event and what that person's criminal history is. So as a defence lawyer, it's our job, I guess, to round out the person a little bit more. Who actually is this client? What's going on in their life? What were the factors that may have led or contributed to offending? What are they doing about addressing some of those factors that led to the offending? How can we support them in addressing some of the factors that led to the offending? That's so the court can consider rehabilitation, but also so the court can consider community protection. If somebody's offending is all related to their drug use, and we can show that they've been well engaged in services, and we can show that by addressing the drug use and addressing the underlying contribution to offending, then the community protection is already there, and potentially a more just punishment will be a little bit less than for somebody who has made maybe no efforts or minimal efforts to address the drug use. I guess as an example of this, we had a client who was charged with resisting police arrest and an assault on an emergency worker. And that happened in the context of a fairly significant overdose, where they were hypoxic and being treated with oxygen, and they were coming in and out of consciousness. When they came out of consciousness, they saw a police officer there who was there with the ambulance worker, and panicked and started thrashing out, and they were charged with assaulting a police officer. We had a support letter from the organisation basically just saying that this person has attended for however many years. This is their relationship with staff. This is how we know them. This is the services that are available to them. And in the sentencing remarks, the magistrate actually said that if it hadn't been for the support letter, they would have given them a custodial sentence. So they would have sentenced them to prison. But because of that letter, they ended up getting a good behaviour bond. So that is a really marked, significant difference, but for the same act. The act itself hasn't changed. They've been found guilty, but it's, I guess, about the magistrate being able to understand the broader factors and work out, well, what's a fair punishment under the circumstances. The other thing that we sometimes use letters for are trying to resist warrants. So today, for example, I have a court matter and the client hasn't turned up. That's quite common for a lot of our clients who are homeless or don't have phones. If they don't turn up, the court can issue a warrant, which means police can arrest them on the next occasion. It's quite common for me to stand up and sort of make submissions why a warrant isn't in anyone's interest, usually because it's low-level offending, the client's quite vulnerable, it's a kind of waste of resources, basically. I can contact them at outreach, etc., etc. Again, by being able to show a letter to say this person is engaged in outreach and this is how we can reach them, can be really beneficial. The other one is bail, when people get remanded because they get arrested and the police refuse bail and they go before a magistrate. Again, I'll elaborate a bit more on bail, but it can be really useful to show that this person has supports in the community, which is why bail might be appropriate. In terms of what you should provide in a letter, look, as I said, keep within your comfort zone, and the letter is really about your area of expertise. So what does your service do? How has your service supported the person? Or alternatively, what can your service do to support the person if you haven't commenced as yet? or only in the very early stages. I think it's always really important to put in what the alleged offending is, so that requires consent from the client for us to let you know, or they let you know themselves. But I think the letter holds a lot more weight if you're writing a letter saying, I'm aware that they've been charged with theft or an assault or possession of drugs. Clearly writing about how the person has engaged, or alternatively, if they haven't engaged, some of the mitigating factors. So you can say things like, we want people to be honest in the letters. So engagement has been somewhat sporadic. However, I'm aware that they are currently experiencing homelessness at the moment, etc. And the other thing the focus is on in how your service can continue to support the person if there is ongoing support available. Look, getting the basic rights is really important, and addressing it to the presiding magistrate at the relevant court. One focus that I would sort of talk about is trying to keep it strength-based. I'll keep on this. Not keep it strength-based, but trying to also not just make it purely deficit-based. I'm slipping back into health language a little bit here, but almost all the clients that I'll deal with have got pretty significant social disadvantage, and we can sort of get caught in the trap of focusing on all of the negatives. If the client has particular strengths, or they have particularly strong relationships with some workers, or they've been doing other things well at your organisation, I think it's really nice to touch on that and to sort of humanise the person. As an example, again, we had a client who was facing some assault charges, and this is a client who has got very significant heroin dependence, also established diagnosis of schizophrenia, low literacy to the point of being unable to read or write, but also has very, very, very strong, and this came out in the letter, that they attend one of our drop-ins every day, and they talked in the letter about the strong relationships that they've had with staff members there, that they often stay for a cup of coffee or a cup of tea at the drop-in with staff, that they've been seen to de-escalate other events on occasions that have happened at the drop-in, that they do not necessarily treatment, but they do other psychosocial or social activities such as the pizza making, haircuts, art groups, the movie sessions that they run. And as I said, it sort of takes the client from being somebody who's done this act and who has a lot of really significant challenges, to sort of recognising that, despite these challenges, they have some really, really positive and incredible resilience or other positive relationships. And again, we can get some really good outcomes if we're able to, I guess, round the person out and colour in the edges. Again, just briefly on letters, keeping it balanced and objective always. I always talk about this concept of, I guess, of being orientated to hope. Look, we know that a lot of our clients will often have sporadic engagement, or maybe no engagement, or potentially have been asked not to come to the service for a period of time because of some events. We're not asking you to, lie or to write things that you're not comfortable with. I guess what I always talk about is that orientation to hope. When I worked in health, I knew, that clients, and even now in the law, may not always take the supports that are available for whatever reason. They may not have the resources at the moment, they may not have the mental load, but I was always optimistic that I could keep offering and keep suggesting and keep trying to meet them where they're at. So I guess always being orientated to the hope that we can potentially put some things in place, while recognising pragmatically that it's not always going to be the right time or always going to occur. And I guess if that's a really helpful, I think, flavour to have through in the letters. You can be upfront about the fact that engagement has been poor, but these are what you'd be happy to continue to offer the person. Again, keep them short and sweet. For the vast majority of magistrate matters, 1 page, 1 or 1.5 pages is plenty. And I guess I'll focus on that idea of don't go out of your comfort zone. You may get pressure from clients to say, tell them I didn't do it, or tell them I didn't do this. But again, your role here is to talk about what your role is as a professional. So focus on your area of expertise and your knowledge. What is the service you provide, and how does the client fit in with that, or how can they fit in with that? You don't need to make comments on whether or not you think they're guilty, or I can't believe that they would do such a thing. you can just say that you're aware of the charges and just state that during our environment, the client has always, or the client is generally presented as, or the client has done X, and how you can keep supporting, as I said. Look, if the client's told you things potentially about a mental health history that you can't confirm, or potentially often comes up, developmental trauma or things that may have occurred in their past, but you're not able to strictly confirm that, then you can just write that the client has reported or the client has revealed a history of, childhood development trauma of X. Again, always assuming that the client is comfortable with this. It is an open court. Letters don't often get read out, but it is their life and things that are getting put in front. I always talk to the client before I make my submissions to see whether or not they're comfortable with me talking about things that may be fairly deeply personal. And I just think that's, I guess, good practice. So I'm just checking the time, making sure how I'm running here. Okay. In terms of the other question, that's a big bit on letters and reports, because it is, I guess, quite a large aspect of what we'll request as lawyers, and often, I guess, an area of what I've found, it can be quite an area of angst for some services and concern about what the letter will be used for. So I hope I've clarified that a little bit. In terms of the other question that we get is, well, how can I help if your clients come to you and said, hey, I've got all these legal matters, I don't know where to go. What are your options? Look, if you're in Melbourne, you can contact the local community legal centre. Almost all areas in Melbourne will have one. If you're calling from the regions, I used to work in Ballarat in Victoria. They have a community legal. Bendigo would have one. Geelong would have one, etc. I'm almost certain they would have one. So look, if you're in Melbourne, the Fitzroy Legal Service, you can always call and at least just ask, where would I refer this person to? If they're in the City of Yarra or the City of Darwin, great. We can, or even if they have a very loose connection, give us a call. We've got, as I said, some specific services. So the Q Plus law has a fairly wide intake. As I said, the drug outreach program has a fairly wide intake. St Kilda Legal Service, which I think is now called Southside Legal Service, has a specialist work for legal service for sex workers. There'll often be that in Melbourne has one for police accountability. So if clients have got concerns about how they're treated by police, so there's often little niche areas that you can get your clients involved in. Other areas, legal aid, of course. Each state will have its own intake. Clients can attend court on the day, and this is very common, and just get what we call the duty lawyer, so the lawyer on duty. They may not get ongoing casework. They may just be given some just general advice at the start and then have to self-rep. For those of you that don't know, for you to get funded by legal aid for a criminal matter, you have to be at risk of a custodial sentence or being sent to prison if you're found guilty. So that can be a pretty high bar for some of our clients who may have fairly low-level matters. So it means that they're not eligible for legal aid funding, which means that legal aid often won't take them on, and they either have to self-rep or, as I said, potentially go to a CLC. We fill that gap to some extent. We don't rely on legal aid funding. I can see clients pro bono. I get a wage and I'm not paid per client. So that's a gap that we can fit, and a lot of our CLCs can fit in. The other option, I guess, is a private lawyer. A lot of private criminal firms will take on legal aid clients. So if they're eligible for legal aid, they just get paid the legal aid amount. For want of a better analogy, it's a little bit like Medicare, like a bulk billing health service. There's some clients, if they qualify, and I guess a private lawyer can claim that bulk bill fee. That's the best way I can explain it. So that will often be like why clients who are quite vulnerable may have a private lawyer. And as I said, a lot of most criminal firms will take legal aid matters as well. The other option is to self-fund if they have the means to do that. And then self-representation is also quite common, particularly for things like driving matters, because they're fairly straightforward, and because they have mandatory sentences, there's often very little that a lawyer can do. So that's the other option that people have. In terms of helping clients prepare for court, if they don't have a lawyer who's helping them with this, or you want to be able to help, or it's an area of some concern, things that you can do. The one thing is making sure they've got the right date. So I will just show you, in Victoria, we have a thing called EFAS, which is the electronic filing system. I will just try and see if I can get this up now. For those of you that haven't seen it before, this is what it looks like. So if you just type in Magistrate Court list or the EFAS list into Google, it'll come up with something like this, basically, and you can search for a case. It's got a lot of things that you need to put in, but you only actually need to click if it's criminal or civil. So general criminal, and then you can even just a last name will do. So as I said, I've just put Smith in here as an example. And as you can see, it comes up with all the different Smiths that have court, what date it is, and which court it's at. So this can be a really helpful tool if your client's worried they might have court. There is some limitations. One is that it relies on the correct spelling. Very common to have variations of spelling or potentially clients given a different name. The other thing is it only shows matters that are listed in court. So if the client hasn't attended and warrants have been issued, it won't show up here. Family violence matters also don't show up, but still very, very useful. And it's a really good place to go for the first thing to confirm. Are they appearing online or in person? Again, this would probably be something that a lawyer's done, but if they're appearing online, trying to get them in a quiet place, health services can be really beneficial here, that if they don't have any data to do it on their phone, that they maybe be able to come in or use the Wi-Fi, have a quiet place, particularly people that are homeless. We're moving much more back to in-person appearances, but online still does happen. Do they need an interpreter, work, child arrangements? Do they have caring responsibilities? Who might be able to help with that? Have they got support materials like letters ahead of time? You might not be the only service, so it might be helping them try and get some other letters from other people. And do they have friends or family that might be able to attend? One thing I would just say to be aware, just be a little bit aware of, is when friends or family are attending, make sure it's actually a helpful person to attend. One trap is that sometimes there'll be family violence orders and they may be bringing the person who is protected by the family violence order. So just to be aware of that. Again, just focusing on the day of court, do they have the relevant documents? Look, the court will have all of them, but it doesn't hurt to bring in if they've been given, the brief or the charges. When they get to court, to check in, so going up to the counter, telling them they're there. Ideally, get to court as early as you can. Courts don't actually generally start till 10 o'clock, and they often tell people to get there at 9:30. I always get to court nice and early. If you get to court early, you almost always get called nice and early. If you come late, you run the risk of a warrant being issued because you didn't turn up, or having to wait around all day. If they get sick, being able to provide even just a short email or letter saying, confirm that the client's sick, or the client has attended and appears unwell, or the client has called and said they're unwell. Something is better than nothing. So even if if the client's not going to turn up to court because of any reason, family emergency, they're sick, dealing with other things, like any contact with the court to at least sort of let them know, or to their lawyer, is better than nothing. Other just important things about working with legal representation. I have a very tenuous arrangement here to try and make myself look nice and centered on about 4 different boxes, so it was always due to fall over. Other important things is you will often know the client better than the lawyer. Sometimes the lawyer may have only met with them once. Don't assume that the lawyer knows things. Again, with the consent, feel free to reach out and say, are you aware that they've got this mental health history, or that they've got these caring responsibilities. Sometimes things might not be obvious, like mental health when English is a second language. Sometimes there might be things like, as I said, homelessness, financial difficulties, other services they might be involved in. If you're aware they're also involved in, maybe they've only had one appointment with you, but that they've done a full treatment regime somewhere else, that can be really helpful to know as well. There can be a bit of a difference between legal privilege and health disclosure. Generally, we're all pulling in the same direction, but I know, as I said, coming from health, there's often mandatory disclosure requirements, whereas everything in the law is privileged. Also means that on occasions the court can subpoena health documents as well. It doesn't happen that often, but it can happen, whereas they can't for legal documents. And I guess from a legal point of view is that I'm strictly bound by privilege. So even if I think there's things that would be very beneficial for you to know as the health service, I can't tell you without that express consent of the client. again, just that can be sometimes an area of tension. Also, as a legal practitioner, I'm not allowed to mislead the court. So sometimes, clients can potentially give information that's unhelpful to me in terms of me trying to defend them. They may be very open in talking about that with you as the health professional, and I'd encourage them to do so, but it may not necessarily be helpful to me as a legal practitioner to know. That isn't to say I'm trying to deliberately obfuscate or mislead the court, but sometimes what you do in legal matters is you're not saying that they didn't do it, you're rather just saying that there's not enough evidence, and you can put forward potential alternative hypotheses that the prosecution haven't considered. However, if I know for a fact that something happened or this occurred, then I can't really put forward too many alternative hypotheses. So it's then just putting the prosecution in proof. So that's just another little slight tension that can come up sometimes. It's also why sometimes legal practitioners can't attend, or it's not a great idea always for legal practitioners to attend care team meetings, because things can often be spoken about potentially a lot more openly in the care team meeting than they may in the legal privilege. Hidden issues. So just to focus now on the last sort of 10, 15 minutes on the hidden issues that can come up in the law. One of the really common ones that comes up is what we call the burger with the lot. So that's when the client has potentially only done one, I guess, offence, but they get charged with a whole host of different charges. The most common one that comes up is things like drug charges in particular. Often what they get charged with will be based on the amount, and trafficking can have a really wide definition. So if someone's found with, let's say, for heroin, for instance, a trafficable amount is anything over 3 grams. So they get found with 3 grams of heroin on them, they can be charged with not only possession, but also trafficking. Only one of those will generally stick, but that's where it can become really useful to know where a client has a dependence issue or very high levels of use, because all of a sudden 3 grams might not be a hell of a lot for them to have on them. It also means that clients who potentially go in with a friend to buy a larger amount to save money, if they're the one found on it, can get found guilty of trafficking because they have a larger amount. Things like complicity, they may not be the ones that strictly trafficking, but they may be assisting the people that are selling by going around and encouraging people to go up and buy or telling people where to buy. This can often happen with undercover police. So they point the people in the direction of where to go and buy. The reason they do that is often that they get cheaper or freebies. But again, they're then seen as being complicit in the trafficking and get charged with it. So it has quite a large net, that trafficking charge, and it is a very serious charge. So again, the big things that can be useful to us is that the charge is purely based on how much they're found with. If we can sort of establish that that person uses quite a lot of heroin, counterintuitively, that can actually be quite beneficial to trying to get the charge downgraded. Record interviews can come up if they confirm in a record interview or tell police, yeah, I've used today, that can sometimes be grounds for being charged with possession, even when they're not found with it. Text messages, things like, hey, do you want to score? Or can be seen to be linked to trafficking. So clients to be wary of that. And I guess the other one is water mistaken for GHB. People that inject jugs will often carry around vials of water or syringes full of water. Police will often charge them with possession of GHB. And the reason for that is because you can't spot test for GHB, whereas you can for things like meth and heroin. So we will then tell them that, no, it's actually water. You have to send it off for a lab, and that will generally only happen if we force the issue and take it almost all the way to saying that we're going to take it to a contest, which is another word for a trial. So those sort of charges can mean it drags out and hangs around for a long time, because that can take some time to get those tests done. Hidden other issues, thefts are a really common one. They'll get found, let's say, for instance, they find an ID in the bin and they pick it up. They'll often get charged with theft of the ID, handle the stolen goods, deal with suspected proceeds of crime. So again, a whole host of charges all for the one event. Stolen credit cards, if they use a credit card and then go make a lot of purchases, they'll often charge them individually for each purchase, when again, we can often roll them up. Police offences, so like resisting arrest, let's say it's one event, there's 3 police officers and they all try and arrest the person and there's some resisting, they'll get charged with resisting all 3 officers, even though it's sort of actually only the one event. Again, we can generally try and get these charges combined, but not always. The other thing to be sort of aware of is offences that are linked to a person's vulnerabilities. So this often happens with people that are homeless. You just, by definition, a lot more public. So things like carrying a knife, even if it's a very small knife and it's what they use to use for their dinner, their everyday tasks. They've never used it for a violent crime, never threatened anyone. They can get charged with carrying a prohibited weapon. We see it often in things like indecent exposure or public exposure, when people urinate, again, when they're homeless, people getting changed when they're homeless as well. Again, and I guess the other thing is when people are homeless, particularly if they're just much more visible. So if there's any sort of excuse, police will often maybe approach, find grounds for searching them, and then they can be found with drugs on them. So again, just much more higher likelihood to come in contact with the prosecution or police, and then a much more high likelihood of being charged with low-level offences. In terms of other things that can come up, another really common one is bail conditions. So the way the bail works at the moment, although there are some changes coming in, is that people can get remanded for really, as in put in prison for really minor matters. They can be charged with shop theft and then put on bail. And then if they breach that bail by, let's say, doing another shop theft, they can get charged with contravening their bail, which then means that there's a presumption against bail and means they're much more likely to be remanded. And when people have other vulnerabilities such as AOD use and they're not engaged with services and homelessness, it can be really hard to make a case for why this person should be released. So people end up getting remanded in prison for conditions that, even if they pled guilty, would not result in a prison sentence. I think coming up, at the moment, it's almost 50% of people that are in our prisons at the moment haven't been found guilty of an offence, so are on remand. The other thing that can happen, and then of course, I guess what happens then is people want to be understandably not held on remand and get out, so they'll often potentially want to plead guilty and just get everything done, which means they plead guilty before we've really had a chance to analyse the case or see if we can withdraw a lot of charges. So they end up often pleading guilty to higher charges or more charges than they have to. The alternative is that sometimes they get bail, but they can have all these conditions, such as they can't attend certain areas or curfew or banned from the City of Yarra, which may have impacts on their health services they access. Can also have things like reporting to police, which can be really onerous, and again, much more onerous than any sentence they would have got. And that runs the risk of being found for further breach charges and I guess that cascading effect. If the clients are unsure about whether or not they're on bail, they can contact the court and you can just Google the relevant magistrates court, and if in doubt, you can just call Melbourne Magistrates and it goes through to a central location. If you just type in, hit 2 for criminal matters, and you can just sort of ask, this is the client, this is their date of birth, the conditions on their bail. The other one that comes up really frequently is misidentification in family violence, and typically with family violence being gendered in nature, with the vast majority, although not all, victims, survivors being women. Often what happens here is that women can be charged with a violent offence when they themselves are actually the victim. It can be quite common to, I guess, occur in cases where there can be, I guess, what we call bidirectional violence or a volatile relationship. So it's not necessarily to say that the act by let's say in this case, the woman didn't occur, such as an assault, but that when you're looking at the broader contextual factors and the systemic abuse that's occurred, trying to understand and why the charge isn't appropriate. Because in violent offences there's always a victim, prosecution are generally very reluctant to withdraw the charges at an early stage. So again, they can drag on, which can be quite stressful to the person, particularly when they themselves have been a victim survivor of the family violence. It can be difficult to prove that there has mis-ID has happened, but things that are really beneficial, any evidence of a prior disclosure to a health organisation that the client is happy to share, or if they're seeking support for family violence, and an appropriate assessment can be made around their history of family violence, and an opinion can be given on that is really, really helpful to try and get the charges withdrawn or at least downgraded. But understandably, these can be quite stressful for clients because they feel that they're in an abusive relationship, and this can, I guess, compound the abuse. And we do talk about systems abuse when perpetrators can often use legal systems to, I guess, exacerbate the family violence that can occur. I guess just to sum up quickly, I think I'm getting right on the buzzer here. Look, as I said, particularly AOD services and other health services, support services, big or small, it makes a huge difference for our clients. For even just putting their legal outcomes to one side, people that use drugs in particular are often some of the most stigmatised and marginalised in our community. So any kind of support, whether it's drop-in, whether it's therapeutic, can have a really, really large effect on our client, as I said, regardless of actually what happens with their legal matters. It can clearly also, some self-interest here, help a lot with reducing and improving their legal outcome. And as we talked about, downgrading some of those charges or even potentially getting their charges withdrawn. It really does help the courts give an understanding and also the police on occasions an understanding of who the client is, above and beyond just somebody who has committed this particular offence. And I guess that's the one thing that I will just sort of leave you with is that often the therapeutic goals and the legal goals do align. We sort of all want the same things, but there can be some tensions. In my experience, to be therapeutic with a client is to try and meet the client where they're at. Courts often don't have that patience or ability with time pressures, so they respond to the client as they are now and deal with them as they are now and how they were then. The other thing that can come up sometimes as a tension is that the court and legal representation can be quite bullish on wanting to get people into certain rehabs or treatment, but the client just might not be ready for that. So, there is that tension between mandated and coercive treatment and how that can undermine some of the therapeutic goals. So I would just also encourage you as the professionals out there to, don't be afraid to put your opinion forward in that matter about, where you think the client's at, and if you think this would actually be unhelpful, or your honest opinion about the relative success. As I said, hopefully it's not from our service, but I'm sure that you do sometimes get pressure, maybe from the client themselves, to quickly try and get things done because they've got court coming up. Again, it can be a great motivator, but as we all know, intrinsic motivation is often far better than the extrinsic. That's the end of my presentation. I think we do have some Q&A now, so I'll throw over to Rebecca. I'll try and answer them as best I can. Also happy to take some on notice. My colleague, Adam Wilson, is a criminal law specialist, so anything that's quite high-level detailed criminal law, I may have to pass off to him, who was unavailable to make it today. But otherwise, I can try and answer what you've got.
Thank you so much, Tristan. Yes, I do have a few questions for you. Does Fitzroy Legal Service refer clients to the assessment and referral court? And how frequently? Is it useful, beneficial, and are good outcomes seen?
So yes, we do definitely. I've got a number of clients in the ARC court, so I'll refer to it as ARC, which is the Assessment Referral Court. Again, for people that are maybe interstate or unaware, this is a court that is for people with, I may get the criteria slightly wrong, but I think it's for people with a mental illness or clear cognitive impairment. Generally, people that have had a lot of contact with the criminal justice system and mainstream, I guess, services or justice responses just haven't been successful. Or alternatively, they would want or that they would benefit from, I guess, a more therapeutic wraparound kind of service. So what happens in an ARC court is they get referred, they get assessed, and then they get, if they're found appropriate, they get allocated an ARC worker who will then sort of come up with a care plan. And that can involve things like getting them linked in with getting certain assessments done, like let's say a neuropsych assessment to confirm whether or not they've got an ABI or certain learning difficulties. That may help them get linked in with various services, maybe NDIS applications, maybe beneficial trying to get them linked in with other social services, AOD services. So basically they get allocated that caseworker. it's a really great service. ARC does require clients to attend monthly to court, so every 4 weeks. So there is that judicial monitoring. So I guess what it does is it leverages the, I guess, authority of a court to try and get clients to engage in various services and also access to certain services. So it can be really, really great, and I've had some really great outcomes for clients. It can also be quite demanding for clients, particularly clients that have difficulty attending court for whatever reason or are quite apprehensive about court. So some clients, for whatever reason, may just want to get their matters over and done with very quickly. Others may be in more of a space or be able to be supported to try and engage in ARC. Again, the things that ARC really don't hear from lawyers very much. So whilst I attend the ARC sessions, the court is generally more interested in hearing from their supports. So if you do have a client who's going to ARC, then actually you attending can be great. The magistrates, it's much more, I'll use the word laid back, but I guess sort of court, in that the magistrate comes and sits on the table. It's much more of a conversation, and it's much more about how can we benefit this client rather than are you guilty and how do we punish you? So that's a very long way of saying, but yes, definitely ARC can have some tremendous outcomes for clients and life-changing outcomes, but it's not necessarily for everyone.
Thank you so much. Just in relation to legal aid, does a client have to plead guilty to be eligible for legal aid?
No. So I guess I'll caveat all by saying I'm not a legal aid grants expert, but definitely clients can be wanting to contest their charges. It's a slightly different test for whether or not legal aid will fund you if you are trying to contest your charges. Without getting into all the nitty-gritty of their eligibility, if you're a youth, you're automatically eligible for criminal matters, I'm fairly sure. Child protection matters, generally always eligible, particularly the youth or the children in question. For criminal matters, if you're an adult, the test, if you're planning to plead guilty, is are you at risk of going to prison, and you don't have a reasonable chance of acquittal. So I guess they don't want people just pleading guilty to try and access funding. If you're trying to plead not guilty or thinking of pleading not guilty, it's still that you're at risk of going to prison if you are found guilty, but also that you have a reasonable chance of acquittal. So if your case doesn't have any merit and you want to challenge it, legal aid may not fund you, even though you're at risk of going to prison. They do have that sort of, I guess, legal analysis to work out whether or not the case does have legs. Again, there can be some slight caveats to that. People that have a significant cognitive impairment or engage in an area mental health service, for instance, can sometimes access funding under what we call special circumstances. So there may be more leeway given there around legal merit. But generally, that's the test. So you definitely don't have to plead guilty to get legal aid funding, but your case has to have some merit.
Thank you, Tristan. Look, I would assume this one's a yes, but I'll ask the question anyway. Do you need permission or consent from the client in order to represent them?
Yes. So that can often happen when I get referrals from health, my outreaches. They'll get in contact and say, hey, X wants to your legal rep. Is that okay? And can you let us know what they're facing, and we'll get them linked in with some services? I can say, sure, I'm happy to take the referral, but I can't share any information until they've given me that consent. And I guess also I can't just turn up to court if the client hasn't let me know. Look, the way our service works, because a lot of our clients are itinerant, don't have phones, we will generally accept verbal consent that they've at least shown an interest in me representing them. And it means I can get some of the ball rolling in terms of maybe requesting some of the charges and things like that. But I wouldn't be able to progress it any further than getting like that initial information without the client being happy for me to represent.
Thank you. Thank you. Does the court keep a record if clients self-represent?
Yeah, it'll generally be on the court record. Did they attend, and who represented, if anyone.
Thank you. Sorry, I think it's just a follow-up to the question around consent. That sometimes state trustees are essentially the client, or the client might be under state trustees.
Oh, as in the guardian, sort of. Yes. Yes, that becomes an interesting area, yes. But I guess if they've got legal power of attorney or that they've been appointed to, make decisions on that person's behalf, then I would say that would be appropriate. Yeah.
Thank you. Can you speak to the risk of clients using pay ID when engaging in trafficking? Can this be used as evidence purely as suspicion?
Well, that's a great question. I haven't come across that one, so I may have to take that one on notice. And if the person's happy to provide their email address or to the organisers, AOD re-trafficking, okay, and whether or not, I guess what you're looking at there is what there's bank records saying that there was various pay ID transactions occurring. Look, the short answer is, without having ever seen it or know what the case is, yes. I mean, I would say that they can always look at bank records, but it might be quite a circumstantial case. People, I guess, very rarely will put in the transaction description that it was for drugs, or hopefully they don't. But I guess if they can show, different monies coming in and out, all of a sort of uniform, so those sorts of things, and they've maybe got other info like text messages or being found with drugs or large amounts of cash. They may be able to make what we call a circumstantial case around, well, we think this has been used for trafficking.
Thank you. Sorry, I'm just weighing up. We've got a lot of questions and not much time. So I'm just going to take them in order of receiving them.
I can stand a little bit longer if that helps. But I appreciate people have better things to do.
Thank you. How can non-legal service providers support clients experiencing any of the burger with a lot, hidden crim law examples, and I guess referring to the slide where you talked about, reducing a burger with a lot to perhaps just a sausage?
Yeah, sure. So I guess it's hard when you're not the legal representative to do that. I guess as a non-legal representative, first thing I do is, if someone has got a whole host of charges, would be to try and see as far as you can you link them in with a legal representation. So that would be, I guess, going back to that slide about, is there a community legal centre available? Would they be eligible for legal aid? Even if people aren't going to be eligible for legal aid ongoing, on the day of their court matter, they can attend and ask for legal aid, and they'll be given some general advice. So then what tends to happen is, or they may just get a one-off sort of benefit if they've got particular vulnerabilities. So let's say, for instance, a person they're not going to be eligible for legal aid ongoing, but they've got like a whole host of theft charges. The legal aid lawyer would be able to, I guess, give them some information. Then what we do is, the client may then have to negotiate with police themselves on the day and say, well, can we try and downgrade these charges? That can be a really daunting thing for clients to have to do, particularly if they've got pretty fraught relationships with police. Again, I can't speak for how legal aid work everywhere. It can be a workload issue. It can be the particular legal aid duty lawyer on the day, whether or not how much they may help that particular client with that negotiation around charges. So in terms of what you can do as the non-legal representative or the non-legal service, trying to get them linked with a lawyer is really, really useful. Even if the legal service may only just provide that initial negotiation help, and then they let the client go and sell for it once the charges have been, downgraded. Alternatively, if you've got the capacity, attending court with them on the day, but that can be a full day wiped out. You've got to wait to see legal aid, and you've got to wait to see negotiations with the prosecutor and those sorts of things. So that would be, I guess, my advice. If you can, try and get legal advice, or at the very least try and get the client to get some general legal advice about how they can do it themselves. Yeah.
Thank you. Final question. If a client is involved in AOD consumer participation work, for example, they're part of a focus group, or they're on a consumer advisory committee, would that be received in a positive way by the magistrate?
Yeah, I imagine that this is, if you're talking about consumer groups, so like, sort of lived experience, peer work, sort of led, forums or workshops or process design, service design. Absolutely, yeah. And I guess from a legal representation I would only ever request support letters or information around a person's AOD use if it was relevant to their charges. So, if I know a client's got, let's say, drug use, but their charges are absolutely unrelated to that, so it might be, running a red light or something, I wouldn't necessarily be bringing up the AOD. But so I guess if services are concerned that, well, hang on, if I provide this information, is it going to look worse because it basically shows that they are still using or that they use drugs? As a lawyer, I would only ever be asking for the info if it's already going to be apparent or I'm already going to be making submissions around their drug use. And the reason that we do that is because courts hopefully are very interested in why the offending happened.
Mm-hmm.
Because they want to try and work out, well, how do we try and mitigate or reduce the risks of future offending? So if I can sort of explain that, look, drugs were a driving force or one of the criminogenic factors or precipitating factors, but then I can talk to the factors of what they're doing to address it or how the services that might be available, then that's really beneficial. So very long-winded answer to say, yes, absolutely. I think clients using their lived experience and I guess helping others or helping service design to make things more appropriate for people or reaching out to groups that might be hard to reach would absolutely be seen favourably or should be. I mean, it does depend on the magistrate, but should be, yeah.
Thank you. Thank you so much. Sorry. And just finally, how do people make referrals to you?
Yeah, so I try, again, coming probably from the health background, I I try and make referral process as easy and as possible. So really all I need is a name and date of birth and that they've consented for you to get in contact with me. So that can just even be writing, they've consented for me to get in contact. If they've got a phone number, great. If you can get other information about how I can get in contact with them, anything above and beyond that's a bonus. So, if you know about when their charges are or, other services they're involved in,
Mm-hmm.
that's it. But I guess for me, my sort of intake criteria is they're involved in those City of Yarra sort of AOD services. If they're potentially outside that, let's say you're an AOD service or something similar, not in the City of Yarra or City of Darebin, you can still reach out to me if you like. I may be able to point you in the right direction, but otherwise it would be the local CLCs in your own area or even calling, I guess, this Fitzroy Legal Service general number, and they would potentially be able to talk about appropriate referrals or where you might be able to go. Yeah.
Thank you. And then in terms of contacting you, is that a phone call straight to Fitzroy Legal Service?
Yeah, no, it'll be straight to me. I can give you my mobile numbers in my email. But yeah, you can call the general number, and I'm happy for them to give out my mobile number to people. Happy for my clients to have a mobile number. If they're using
Very generous.
that's absolutely fine. So yeah, I can't always take the call, obviously, but I try and get back to people. Email can be useful as well, particularly if it's the initial call, just because then I've got it clearly written down, like what the client's name is. I can check for conflicts. That sort of thing can be just useful. So at least I've got, I don't have to scramble for a pen and paper while I'm on the phone. But.
Thank you, Tristan. And I just want to say to you that the majority of the comments I've got is just thanking you for a really useful and helpful presentation. So thank you so much. It's very possible that we'll have you back with your colleague Adam. So thanks again, Tristan, for your time. We really appreciate it. And thank you, everyone. And just a reminder to complete the feedback form.
No, that's absolutely fine. And if there's particular questions or areas that I've missed, I hope I'm okay to say this, but to reach out to the organisers to sort of flag other things you might be interested in. If it's something that myself or Fitzroy Legal Service more broadly can assist with to provide further education, very happy to do. And I just want to say thank you very much to Rebecca, Marion and Ken for the tech help and helping get all this organised and run relatively smoothly, my screen falling over notwithstanding.
Thanks, Tristan. And thank you, everyone. See you later.